Senator Mohamed.
Thank you, Mr. Speaker. Honourable Senators, I rise today to introduce a sunset clause to Bill C-12. At the outset, let me state clearly that the sunset clause I'm proposing is narrowly focused on specific, highly contested changes to the Immigration and Refugee Protection Act introduced in C-12. By targeting these specific parts, the sunset...
We don't hear you well, so can we make sure that the sound is okay?
Shall I start again? Is that better? Can we reset the clock? Every minute matters.
Okay, go
Thank
ahead,
you, Mr.
Senator
Speaker.
Mohamed.
Honourable Senators, I rise today to introduce a sunset clause to Bill C-12. At the outset, let me be clear. The sunset clause I'm proposing is narrowly focused on specific, highly contested changes to the Immigration and Refugee Protection Act introduced in C-12. By targeting these specific parts, the sunset ensures that the most significant new executive powers regarding Cabinet's ability to freeze or cancel immigration applications and documents by emergency order, officer discretion to stop or revoke individual applications and documents, access to refugee protection, and the procedural rights of asylum claimants are the ones that are subject to the mandatory parliamentary reaffirmation. Bill C-12 is presented as a response to a changing global environment, rising geopolitical instability, increasing irregular migration, evolving security threats, and mounting administrative backlogs. Given Canada's position in the world today, it would be irresponsible not to update our security, our border, and our immigration systems. Reform is necessary. But the question before us is not only whether the modernization should occur. The question is how we modernize and what principles must guide that modernization. To remain effective, Canada's immigration framework must evolve alongside the realities of the 21st century, global displacement, geopolitical instability, technological change, and the increasingly complex migration patterns. Canada's international reputation has been built not only on the strength of our immigration policies, but on how these policies are implemented. We are widely viewed as a country that balances security with fairness, enforcement with compassion, and sovereignty with international responsibility. If that balance shifts too far in one direction, the consequences extend beyond immigration law. As I noted earlier in this chamber, during committee review, neither the minister nor departmental officials were able to provide a breakdown of roughly 300,000 cases currently in the immigration backlog, including how many involve students, asylum seekers, or economic migrants. Honourable Senators, how could we be asked to make decisions of this magnitude without empirical evidence? A similar concern arises when we examine administrative backlogs more broadly. Expert testimony cautioned that several measures in Bill C-12 may not eliminate delays. They may simply relocate them. By tightening eligibility rules, accelerating timelines, and expanding abandonment provisions, we may see a significant increase in applications for judicial review before the federal court, an institution already operating under great strain. If we simply move the bottleneck downstream, we've not solved the problem, we've relocated the address. When we ask officials what impact these provisions would have on reducing the backlog, whether improvements were expected within 1 year, 2 years, or 5 years, no modelling was provided. When government cannot provide the data or projections necessary to demonstrate how legislation will reduce backlogs or strengthen security, Parliament, as I said yesterday, should pause, because good policy begins with good evidence. Honourable Senators, Canada has faced administrative backlogs before. When the country experienced significant delays in issuing passports, we did not change the eligibility rules for obtaining a passport. We did not narrow procedural protections. We strengthened administrative capacity. Resources were allocated, staffing was increased, systems were modernized. Immigration backlogs require the same practical response: improved capacity, better systems, and adequate resources, not the curtailment of safeguards that protect fairness. This brings me to the amendment that I am placing before you. Yesterday, this chamber adopted an amendment requiring the minister, after 5 years, to table a report on how Bill C-12 is being applied. That amendment strengthens transparency. Parliament should know how the laws we enact operate in practice, particularly when they affect vulnerable people and engage serious legal and humanitarian considerations. It was a good amendment. I voted for it too. But, honourable senators, transparency and accountability are not the same thing. Under the government's amendment, Parliament will receive a report, but regardless of what that report reveals, whether it demonstrates success, failure, unintended consequences, or harm, the law continues unchanged. That's a problem. There is no requirement that Parliament should act. There is no obligation to decide whether the provision should continue, and there is no consequence if Parliament simply does nothing. In that framework, Parliament is informed but not empowered. The amendment I'm proposing ensures that Parliament must decide. It introduces a sunset clause under which certain new and expanded provisions of the Immigration and Refugee Protection Act will expire on the first day of the 6th year once the review is complete, unless Parliament explicitly votes to extend them. In practical terms, this changes the default. Under the bill as drafted, the default is permanence. Once enacted, the provisions remain in force indefinitely unless Parliament later chooses to revisit them. Under this amendment, the default is reconsideration, informed reconsideration. If Parliament believes these measures are working as intended, if they're necessary, if they're proportionate, and consistent with our legal and humanitarian obligations, then Parliament can vote to extend them. Both that extension must be deliberate, evidence-based, and approved by both houses. The law will not continue by inertia. It will continue because of decision. Senator Harder has championed Senator Dean's review of the amendment as giving parliamentarians, quote, greater tools for monitoring the effectiveness of the system, and called it the one that will ensure the system's integrity over the long haul, end of quote. He also warned against what we might call what-isms, the risks of acting without evidence. But parliamentary review, by its nature, is exactly that, a structured examination of what-isms, what happened-isms, what worked-isms, and what should be fixed-isms. A review produces findings. This is invaluable, but it does not compel action on them. The sunset clause is what gives those findings weight. It takes the monitoring that Senator Harder rightly values and adds a fair consequence. Government and Parliament must look at the evidence and vote on whether the rationale for these powers still stands. That is not a burden on the review. It's the review's enforcement mechanism. Surely that serves the framework that Senator Harder cautioned us to focus on. A review tells you what's happening. A sunset forces you to do something about it. Together, they are what integrity over the long haul actually looks like. This reflects a simple principle of democratic governance. When Parliament grants significant powers or restricts important protections, it should also build in mechanisms to revisit those choices in the light of the real-world experience. A sunset clause ensures that Parliament must look again, that it's not obstruction, that is responsibility. I'm going to say again, a sunset clause is not obstruction, it is responsibility. Honourable Senators, I also want to address several arguments that I expect from the government. First, some may argue that a sunset clause is unnecessary because Parliament can always amend or repeal the legislation. That's absolutely true in theory. In practice, once legislation is enacted, it is rarely revisited unless a crisis arises or a problem becomes undeniable. A sunset clause, again, transforms theoretical oversight into scheduled accountability. Scheduled accountability. It must absolutely happen, or those powers fall away. I remind you of the data point I shared yesterday. Of the 51 reviews added to the legislation over the past 20 years, reviews have only taken place 17 times. At 33% success, I think the writing is on the wall. We can do better. Second, some may suggest that a sunset clause creates instability or disrupts operational planning. The opposite is true. A 5-year horizon provides governments, agencies, and international partners with a predictable timeline. If the measures are working, renewal is straightforward. If they are not, Parliament can adjust. This is stability enhanced, not diminished. Third, some may suggest that a sunset clause sends the wrong signal internationally. Canada's reputation is strengthened when the world sees that we combine effective immigration management with democratic accountability. Temporary powers that must be justified through renewal demonstrate confidence in our institutions and respect for the rule of law. Honourable Senators, we must therefore ask 2 simple questions. Should this bill pass in its current form? And if so, what safeguards should accompany it? A sunset clause is a classic instrument of sober second thought. It accepts the bill in principle while ensuring that Parliament retains oversight of its long-term effects. It does not delay implementation. It does not prevent the government from acting. But it ensures that Parliament, not inertia, determines whether extraordinary measures become permanent features of the law. A lot has been said about the speed of which this bill has moved forward. It may not be ideal, but it is what it is. Sometimes circumstance requires to move with urgency. I accept that. But when that happens, we must be open to how we balance that urgency. A sunset clause provides that balance. Because laws often operate differently in practice than they do on paper, unintended consequences emerge. Policies adopted in moments of urgency can become normalized without adequate scrutiny. A sunset clause guards against the drift. It simply says Parliament must look again when we have the benefit of time and evidence, something that is missing from the introduction of this bill. Not every bill requires a sunset. That is true. Very few, in fact, do, but this one certainly does. We must also consider the broader implications of Bill C-12. Immigration is not only about borders or humanitarian commitments, it's about Canada's future. Without immigration, Canada would struggle to sustain labour force growth and support essential services across this country. Immigrants already represent roughly 25% of registered nurses in Canada and more than one-third of physicians, pharmacists, and dentists. I'm going to run out of time, so I'm not going to give you the statistics on the construction and technology industries, but those numbers are quite high as well. Colleagues, the world is in a messy place at the moment. If we want people to choose Canada in the future, we must understand that part of choosing Canada is about trust. I think it's the catchword of the day. Trust that our systems are safe and fair, thereby offering something that other countries probably cannot. In summary, a sunset clause recognizes that good laws are living instruments, evaluated and refined over time. It demonstrates that oversight is not symbolic, but real, and that powers granted in extraordinary circumstances remain subject to democratic control. I'm the first to agree that a sunset clause should not be used lightly. It has been used before in anti-terrorism legislation and emergency legislation. Those bills provided extraordinary powers. Sound familiar? Bill 12 provides for extraordinary powers. Supporting this amendment is not about fear or undermining the bill in front of us, nor is it about casting doubt on the intentions of governments to follow. It is about foresight. It ensures that the powers we grant today remain justified tomorrow. And with that, I move that Bill C-12, as amended, be not now read a third time, but it be further amended on page 35 by adding the following after line 16. Part 8.1, Immigration and Refugee Protection Act, Sunset Provision and Review. 75.1, the Immigration and Refugee Protection Act is amended by replacing Part 5, main heading with transitional, quote, transitional provisions, consequential and related amendments, coordinating amendments, repeals, sunset provisions, and coming into force. 75.2, the Act is amended by adding the following after Section 274. 274.1. The following provisions cease to have effect at the start of the 6th year after the day on which the Act respecting certain measures relating to the security of Canada's borders and the integrity of Canada's immigration system and respecting other related security measures receives royal assent unless, before the start of that year, the operation of those sections is extended by resolution, whose text is established under subsection 2, passed by both Houses of Parliament in accordance with the rules set out in subsection 3. A. Section 11.3. B. Paragraph 14.2b1. C. Section 20.01. D. Paragraph 26b.01. Sections 87.3001 to 87.305. F. Paragraphs 101(1)(b)(1) and B2. G. Subsections 101, 1.1 and 1.2, and H. Paragraphs 111.1, 1B1 and B2. 2. That was just one. The Governor and Council may, by order, establish the text of the resolution providing for the extension of the operation of provisions identified in subsection 1 and specifying the period of extension, which may not exceed 5 years from the first day on which the resolution is passed by both Houses of Parliament. 3. A motion for the adoption of the resolution may be debated in both Houses of Parliament, but may not be amended. At the conclusion of the debate, the Speaker of the House of Parliament shall immediately put every question necessary to determine whether or not the motion is concurred in. 4. The operation of the provisions identified in subsection 1 may be further extended in accordance with this section, in which case the reference to at the start of the 6th year after the day on which the Act respecting certain measures relating to the security of Canada's borders and the integrity of the Canadian immigration system and respecting other related security measures receives royal assent, unless, before the start of that year, in subsection 1, is to be read as a reference to, quote, on the expiry of the most recent extension under this section, unless before the extension expires. Thank you. Shukran. Miigwech.